Okay, with that, we'll get started.
Well, good morning, class. That's what I say every year. And Happy New Year. Can you believe it's 2024? What a number. I'm Roberta Robinson. And of course, this is Daniel Wilson, my partner and my son. And we are going to give you an update, what's new in estate planning, so you can follow along in our PowerPoint and in the handout. And we will be doing this presentation live at the RB Rancho Bernardo Library on January 26th, if you want to, talk in person. Daniel, next slide. Here's our website. You can go to trustlaw.us if you want to visit our website. And we have all kinds of resources and materials on the website. And because we're lawyers, here's our disclaimer. We're going to teach you what we know, but it may or may not apply to your individual situation. So be sure to consult with us or an attorney if you have questions about your own situation. I am Roberta Robinson. Can you believe it? I've been in practice 47 years. We are Robinson and Wilson. I'm a certified specialist in probate, estate, and trust law, as is Daniel. I'm very proud of Daniel, and I'm also proud of my 5 wonderful grandchildren. Had to get that in. Daniel, back to you.
Yep, and I am Daniel Wilson, also an attorney here, and I'm more than 11 years in practice already, and so also a certified specialist in estate planning, and I do have a master's of law in taxation, and I'm past president and currently a member and board member of the Rancho Bernardo Community Foundation. And really, this is what we do is estate planning. So we're involved with creation of a brand new estate plan with your will and trust. We also amend existing estate planning documents. So if you're an existing client or have a estate plan that you've had that's 20 years old and the attorney is no longer around, we update those for you. And we also work on the administration side as well. So we would represent a trustee in the administration of a trust, either upon the incapacity of the creator or upon their death. Similarly, we also handle probate. So if you're the unfortunate situation where your estate has to go through probate, we will represent the executors of those estates. So here's what we're going to go over today. It's quite a lot. So hopefully, if you do have questions, you can put them in the Q&A and we'll try to answer them as we go. If not, you can always email us and you'll have our email information at the end of the slides. And also, we will be sending out a copy of these handouts and the slides. And we also have a really more technical handout that will give you as well. And then we will also send you a recording of this presentation if you find it interesting that you want to send it to someone for them to look at. So what we're going over today is the tax law changes. And so there's lots of recent developments and some changes that occurred a few years ago that we're still talking about, that we're actually seeing more importantly of when the law passed, of the actual changes and how it affects our clients after the law passed maybe a couple years ago. So we're talking about the estate tax law, retirement plan and income taxes, basis step-up planning, so that's more income taxes, and a big thing that we're going to talk about again is property taxes and what's changed since we talked to you last year about it. Also, we'll be talking about some changes in our case law that affects probate code and how your estate is administered, how to change a trust, and so we'll just jump right into it. All right, starting with our federal estate tax. So this is something that we're always thinking in the back of our mind about when we're talking to clients is, do you have an estate tax that could be due upon your death? The reason why we want to focus on it or always be thinking about it is that it's a huge tax where you could get taxed on your estate just upon your death on 40% above the exemption amount. This year, every person can have up to $13.61 million in their estate without having to pay a tax at their death. So it's a very high number, and this actually been increasing in the last couple of years with inflation. If you did happen to be in the position where your estate was over that amount, you get taxed on 40% on the overage. So it's a huge tax, and it's due 9 months after the date of your death. Even though we realize it doesn't affect many people and a lot of our clients may not have to worry about it, the reason we're talking to you about it today is that that number is going to change. So starting in 2026, the law is going to automatically sunset. So the exemption amount is going to get cut in half. So it'll be about $7 million per person. Again, when you get taxed on the 40% above that. So in our example on the screen, it shows how big the change could be of whether if you died in 2024 or 2026, it's a huge tax that could be owed as a difference. Fortunately, if you're married, you have the right to double your exemption amount. So for a married couple, they can leave this year, if they were to both pass away, $27.22 million in their estate without having to pay an estate tax. Again, very large estates would only be subject to an estate tax. And still, though, in 2026, unless there's a change in the law, so president could change, Congress could change, they could pass a law and say that now the exemption is going to be either higher or lower. But what we do know definitely, the way the law is written today, is that in 2026, the exemption is going to get cut in half. Between a married couple, that leaves you $14 million that can pass free of estate taxes. How can you get both of the exemptions? So how can you get both spouses' exemptions? If one of them were to pass away, the survivor has to file a federal estate tax return or Form 706, and they elect portability of the deceased spouse's unused exemption. Again, it may seem that this is not really necessary if these numbers are huge, $13 million, $7 million, but it is a way to lock in to minimize potential estate taxes if there's a change in the law if you're the surviving spouse in your lifetime. And so the law could change, your assets could change, and so by filing this estate tax return upon the death of the first spouse, it allows you to minimize the risk of the changes of the law of having a tax due upon your death. So this estate tax return for the first spouse to die is also due 9 months after the date of the death of the first person. You can request an automatic 6-month extension. However, again, with the changes in the law and the changes in sizes of people's estate, people kept missing this deadline of filing an estate tax return. Either they didn't know they had to do it, they weren't told they were supposed to do it, or knew about it but just decided not to, and now having some regrets, they had to file with the IRS and request, can I do a late filing? This happens so many times with so many people that the IRS just threw their hands up and said, forget it. Everyone has really 5 years after the first person died to file this estate tax return. So if it wasn't due, there's some requirements. It didn't have to be due in the first person's death, and you are simply filing just for portability because you want to use that spouse's exemption to add it on to your own, you have up to 5 years after the first person dies. So for all of our CPAs and accountants and financial advisors that are watching, check to see if there's been any deaths in the last 5 years of a married couple where the first person died, and maybe check in to see if they filed an estate tax return.
So what Daniel's telling us is that the exemption is going down. When? In 2026. We used to think 2026 was so far away. It's not. It's 2 years from now. So right now I have $13.61 million exemption going down to 7. What happens with that extra exemption after it goes down? It's lost. It's gone. We've seen this before in tax law, and people are rushing around saying, what can I do? Can I spend my exemption now? Because it's going to go away. Can I use it now? And the answer is you could use it now because you can make a gift all the way up to 13.61 million, file a gift tax return, and there's no gift tax due. You're allowed to spend your exemption now, or when you die, or part now, or part when you die. And you might say, well, that's great. Let me give away a couple $1 million and let me use part of that lost exemption that's going away. And I would say, well, the problem is you don't get into the lost exemption until you've given away $7 million. You'd actually have to give away $8 million, $9 million to bite into the exemption that's going to be lost. There's my gravy pourer to try to explain. You can't get to the oil till you spill out the gravy. So many people who are very wealthy will consider doing this, But for most people, this is too huge a gift to give away. They still need their own assets. And remember, if you give away a gift, and we're going to talk about this many, many times, you're giving the recipient your income tax basis. So if you have capital gain locked into a stock, for instance, and you give that stock away, your beneficiary is also going to receive that locked in capital gain. On the next slide, let's go over the basics of gift taxes. Here I was talking about this immense gift, 13.61 million. But let's talk about more simple gifts. Every year, you're allowed to give $18,000 a year in value to as many individuals as you want. So if you have 2 or 3 children, that's quite a bit. And if you're married, your spouse can also give that away. You don't have to file a gift tax return, and it does not use up your exemption. It's a freebie. That's the annual exclusion gift. What else can you give away without using your exemption? If you want to pay somebody's medical bills or educational costs, unlimited how much you can give if you make the check or the transfer out to the provider, to the hospital, the insurance, health insurance company, tuition directly to the school, unlimited. Go ahead, help as many people as you want. And remember, because we're going to be talking about basis over and over, when you give a gift away, you give the recipient your income tax basis. They don't get a new basis. Daniel, back to you.
And just when you thought the IRS was already taxing everything at the time of your death for an estate tax, there's another tax that they're going to look at. And it's this sort of unknown tax that most people don't really are aware of. And it's called our generation skipping transfer tax. And this is a tax that would be due if you made a gift to maybe a grandchild and you're skipping over your own child, giving it to a grandchild. In that sense, again, there would only be a tax if you gave more than the $13.6 million away. So really how this comes up in our practice is to say, well, what if I want to leave my estate to my children for the rest of their life? All the inheritance stays in trust. The money can go out to the child to pay for their support and education and living expenses, but the principal really stays in the trust for the rest of their life. Upon their death, then it goes to their children. So that's a way to leave assets to grandchildren by keeping it in what we call a generation skipping trust. Really, the term generation skipping, it's really in the eyes of the IRS because they, upon the death of the child, whatever that trust grows to, it's not taxed in the child's estate. So as an example, if my mother set up a $5 million trust for me and I get to live off of it for the rest of my life, it grows and grows and grows, and it's worth $50 million at the time of my death when it goes to my kids. That $50 million is not looked at for estate tax purposes upon my death. However, at the time it was created, when that trust was set up after the death of a parent, the IRS will look at it to see, are you above or below the exemption amount for generation skipping? And that would be the time that the trust would be looked at for an estate tax or a death tax. Other taxes that, again, we're always letting our clients know there's these changes relate to a 529 college savings plan. Many people refer to it as a 529 account. And really, this is a specific type of account that you would set up at a bank or financial institution. And you can transfer money into that account, and it can be invested and managed. And the purpose of the account is that it should grow and grow and grow. And if it's used for the beneficiaries' qualified higher education expenses, all that appreciation after the initial, the growth in that account comes out tax-free. So it's a way to sort of put money away for college, and then it can grow and be used tax-free. So again, how much can you transfer in without even having to worry about paying a tax or filing a gift tax return? Again, it's $18,000. So that's the annual tax-free amount. So that's how much it would be if you were to make a gift this year. If you maybe have a grandchild that was newly born and you want to set this up, you could just do $18,000 a year every year. for the next until they need to use it. But what if maybe you're just learning about it and you have like a 14-year-old, child or grandchild, and you'd like to put money away for college, but it's not really going to have that time to grow. You could actually front load those 529 accounts and put in 5 years worth of gifts into that account all in 1 year. So if you wanted to set up this year, it could be $90,000. And again, whatever it grows to, it's not taxed when it's used for qualified higher education expenses. Other changes with the law under this new Secure 2.0 Act that we're going to talk about more later is that if you have unused 529 plans, so maybe, the child got a scholarship to go to school and now they have hundreds of thousands of dollars in their 529 plan. Or what if, they just didn't use it all. They went to 2 years community college and got another, 2 years to get their bachelor's degree. You have a little bit of this extra money in a 529 plan. You now have the ability to transfer up to $35,000 into the beneficiaries, the students' Roth IRA. So they can have this little bit of extra money, put it away in a Roth. And again, same rules for a Roth. It can grow and grow and grow tax-free. And so there are some caveats. Again, the cap right now, it's only $35,000 that you can put into a Roth. And the 529 account has to have been open for 15 years. So the IRS says, no, no funny business here. The account has to have been established, 15 years ago. So a really, purposeful account that kind of just had this extra money left over.
I'm back with basis. You're going to have dreams tonight. Roberta just talks about basis. So let's talk about the basics and what we're seeing in our practice. Let's say I bought a house for $400,000. That's my basis in general. And now it's worth $1 million because it's astounding. But in California, everything's worth at least $1 million. So I have gain. I have capital gain. The difference between my cost, 400, and the value, 1 million, I have $600,000 worth of capital gain. And if I sell that home in my lifetime, I have to report that gain and, figure out what kind of tax planning am I going to do about it. But I definitely have that gain. On the other hand, I'm using me as an example. If I pass away and I own that house, my basis changes just because I died. And it goes all the way up to fair market value. Basis becomes the $1 million. So whoever inherits that house could sell it with no tax on gain at that point in time. If it continues to appreciate, they do have to report the profit from after my death. So we call that stepped up basis. When basis adjusts at death, and by the way, it could be stepped down. Right now, we're in a period of inflation. Everything's going up, but we have been in recessionary times where basis can possibly go down. The one thing that does not get a new basis is retirement plans and annuities where there's deferred income taxes already. So we're talking about real estate, your investment accounts, not IRAs and Roths and annuities. Next slide. All right, now let's get into the weeds here. Most people have revocable trusts. It's a trust that you can revoke, you can amend, you can change it, you can move assets in and out. It's used as a vehicle to avoid probate. It's a container where anything in it avoids probate at death. Some people additionally set up irrevocable trusts. Well, what's an irrevocable trust? It's exactly what it sounds like. It can't be changed. For some reason, you're setting up a trust that you're not really going to be taking things back from. You're maybe using it for making gifts. Or let me go through some types of trusts. A married couple might have said, or continue to say, at a death, I don't want my half of the estate to go to my spouse. I want it to stay in trust for my spouse. We call that an AB trust, and trust B is an irrevocable trust for the benefit of my spouse. I might say, I don't really want to leave my estate outright to my children. I want to leave it in trust for them. I want to protect them from all kinds of things. When that trust is created, that is an irrevocable trust. What's interesting is when I die, again using me, my revocable trust assets are in my estate. They get the new basis, but the irrevocable trust assets are not in my estate. They don't get a new basis. Let's go to the next slide. So what we're seeing in our practice is that we are going to court somewhat regularly to ask the court to modify an irrevocable trust that was created in the past. Why? We're trying to get a new basis on the assets in that trust at death. Normally, there is no new basis. So let me give you an example that we're seeing many, many times. I have a widow who survived her husband by 25 years. He died very early, and they set up an AB trust. The A trust is her trust, the alive person's trust. It's revocable. When she dies, it gets a new basis. The B trust is her buried husband's trust. That's how we remember it's B. And normally, when she dies, it does not get a new basis. But those assets have been appreciating for 25 years, and now they're like triple in value. She's upset when those assets go to her children. If they sell the Trust B assets, which they probably will, they're going to have an enormous capital gain. She wants to make sure that Trust B assets get a new income tax basis without causing an estate tax at her death. So we go to court. We tell the court the idea of the AB trust was to minimize taxes. That goal is no longer being achieved the way it's currently written because the survivor has this enormous exemption. We could use her big exemption plus get a new basis on Trust B. So our goal in tax planning is to kind of wipe out the income tax on Trust B. And we ask the court, please insert some language into the trust called a general power of appointment that will cause Trust B to be included in the survivor's estate when she dies, so it will get a new basis. And this is somewhat of a popular modification petition that we're bringing this past year. And they're all granted, by the way. All right. What do we have next? More basis planning. Well, here's the son who works at Google. He's one of these new millennials. And there's his dad. And he said, Dad, we're good buddies. I've got a lot of Google stock that has increased in value. I'm sitting here with a lot of capital gain. How about this idea, Dad? I'm going to make a gift of some of my Google stock to you. You hold on to it. You got to live for a year. And in your will or trust, you say that that stock comes back to me at your death. Why would you do this? Because if the Google stock is included in Dad's estate, it gets a new income tax basis when it goes back to Sonny there, and he could sell it without gain. So we call that upstream planning, up to the next generation. Now, Dad's thinking, well, that sounds pretty good to me. And he's thinking, this Google kid of mine, he makes a really good living. Boy, you should see his payroll. He doesn't need the Google stock. He gave it to me, but I'm going to change my trust. I'm going to leave it to my other kids. And of course, the son would not be happy about that. So the son could create an irrevocable trust for Dad, put the Google stock in, and if Dad has one of these general power of appointment over the stock, it will get a new basis, but it must come back to the son because the trust is irrevocable. All right.
All right. Again, sticking with taxes, we're seeing sort of a trend. Again, part of this presentation is to go over some of the trends that we're seeing in our practice. And again, a lot of what we talk about are taxes with our clients. And we're thinking, what about income taxes of these trusts? and estates. And it's important to know that a trust and estate is an entity on its own. So not your revocable living trust while you're alive. It's not an entity. It's really you as a person, in that you set up your trust, you put your assets in the trust, your bank accounts, your investment accounts, all of those are registered under your social security number. It's as if the trust doesn't exist. But upon your death, the trust becomes irrevocable. Again, since you're no longer alive and you can't use your social security number on an irrevocable trust, you apply for a tax ID number from the IRS. And so this is the creation of the entity of an irrevocable trust. Now, this trust, as long as it's in existence, has to file an income tax return. And so for the federal income tax return, it's a Form 1041. For California, it's a 541. And so these are these tax returns that have to be filed every year that the trust is in existence. Well, unfortunately, a lot of people don't really like paying taxes in California. And so we're seeing people, coming in and asking us, can I get this trust taxed to another state? And we kind of look at those facts, and California, as you can imagine, wants to sort of reach out and grab as much assets as they can to be taxed. And so they have a very broad way of taxing trusts, where if a trustee or a beneficiary is a California resident, it's going to be taxed in California. If there's California source income, like a business or real estate in California, it's going to be taxed in California. And a new change in the law, that's kind of narrow, but there are these type of trusts that people would create to say, even though the trustee, the beneficiary, everything's in California, the way we set it up is we're going to create a trust in maybe a non-income tax state, like we have on that list below. So Nevada would be a close one to California. So you say the taxing location of the trust is Nevada, and then we're going to put some assets into the trust. And this is what we call an ING trust, an incomplete non-grantor trust. And so this is a way to sort of get the trust taxed out of state. However, the law has changed this year to say, nope, you can't do that. And even though the law was passed just this last calendar year, let's say in like July, it actually went retroactive to the beginning of 2023. So again, there's some estate planning attorneys may have set up these trusts and with the understanding that it won't be taxed in California, but now going forward, they would be. And why is it such a big deal to be taxed at a trust? And this is something we try to tell everyone. Trusts are in a compressed income tax bracket. So as an example, for the federal income tax, the top rate is 37%. Whether you're an individual, a trust, married couple filing jointly, all these things, we have the tax rate of 37. But how much income do you need to get to that 37%? As an individual, it's hundreds of thousands of dollars, $600,000 to be taxed at the top taxable rate for an individual. A trust will reach the top 37% with only $15,200 worth of income. So again, it's in a compressed tax bracket, so it reaches the higher rates really quickly. If you add on top of that a California income tax, you're getting to more than 50% taxed on irrevocable trusts. Again, not your personal revocable living trust. These are irrevocable trusts. If they're generating income, so let's just say it's in the investments and there's interest and dividends, that's going to be taxable income if the trust holds on to the income, meaning it gets paid, the trust assets are generating income. If the trust distributes the income in that year to the beneficiaries, the trust doesn't pay the taxes on it. It comes into the trust but paid out to the beneficiaries. The beneficiaries pay the taxes on it, which is preferred because an individual doesn't reach the top tax bracket until they're a couple $100,000 worth of income. And so even if the trust generates $100,000 worth of interest and dividends in the year, if it pays out that income to the beneficiary, it's paid on the beneficiary's income tax return. And so part of our planning, when we talk about estate planning with you all, and you're thinking, you know what, I want to set up a trust for my child. They can't handle the money, so I'll have a trustee be in charge of it. But I don't want any money to go out of the trust to that child until they reach a certain age, meet certain milestones in life. We could say, okay, but we need to balance that with, if the trust is accumulating income, about half of it can go out in taxes. So that's sort of the trade-off of sort of controlling the assets within the trust, If it doesn't come back out of the trust, it could get taxed.
All right, if your brain is full of tax matters, just empty it out, shake it out. Now we're going to be talking about other areas of estate planning law. Healthcare. Well, everybody should have an advanced healthcare directive. Everybody, anybody over 18, make your children do it, your grandchildren do it. That's the document that appoints an agent to make healthcare decisions if you're incapacitated. And the law is pretty strict that the doctors and the hospitals can only talk to the agent holding the healthcare directive. Well, we have two new developments this year. You can now make an organ donor election by checking a box on your California income tax return. So a law was passed that the Franchise Tax Board has to add a box to the income tax return in California to allow people, not make people do it, but allow people to check the box. And then if you check it, you'll be added to an organ donor registry in California. So the law is trying to encourage people to become organ donors. What else do we have? Healthcare facilities can actually designate someone, a surrogate, to make your healthcare decisions if you have not signed an advanced healthcare directive. So it's better that you sign one and you make the choice, but if not, hospitals, retirement facilities, long-term retirement facilities can actually designate a surrogate who needs to be a concerned family member or friend. Ooh, who knows who's showing up. Anyway, it's better than going to court for a conservatorship, but please sign your healthcare directives. You may not know this, but if you're a lawyer, you know it, that since COVID, we have been doing video conferencing with the court. So we used to have to drive down to the court, park the car, pay for parking, on and on and on, wait in the courtroom. But now everything is being done by video conference in probate, largely in civil matters, but not in criminal matters. And the law has been extended to 2026 that we will continue to have video conferencing. That's what it looks like in that picture below. We look at the judge and there are the attorneys. I hope it's a permanent change. It makes life easier on the attorneys. I'm not sure if the judges think it's easier, but it certainly is easier for the attorneys.
And I'll say it has opened our practice to be able to handle probate matters in other counties other than San Diego. So it used to be, if somebody was even in like Orange County or Riverside or Los Angeles, that, we would refer to an attorney to be able to handle a probate matter. And it could be even our own client or something simple where we need to do some petition for instructions. Like it's just kind of a routine thing that we go to court for that, not wanting to drive up to Los Angeles, we would work with another attorney. But now, any county in the state of California, we can handle the matter, appear virtually, and it's the same as if we were there in person. So it really is fantastic for us.
All right, embryos. I had to fight it with Daniel to get this slide in. He says it doesn't apply to that many people. I said, but it's cutting edge. It's our new, our new world. Well, parents, a man and a woman, of course, can create embryos and freeze the embryos for future use. And this is done for various reasons. It could be that someone is older. It could be that they're going to undergo cancer treatment, chemotherapy, and a young person wants to freeze embryos. Well, who is in control of those embryos? Starting now with a new law, the people who are unmarried, it's very interesting. It's for unmarried people, can enter a written agreement where one person renounces the embryos. I have no legal right to them, and renounces their parentage, that they are not the legal parent. This written agreement can be filed in the court, and an order can be obtained of non-parentage, that the donor is not the parent. So I think Daniel's right. It's not going to apply to that many people. But what I'm thinking is it possible with this technology that years and years, decades later, when somebody dies, they still have frozen embryos, and we're as a state attorneys having to figure out what to do. So it's our brave new world. I got my slide in. What else? New sort of property, ADUs. You've probably heard about this. In California, we have a housing shortage, and laws have been passed to allow property owners to build or add accessory dwelling units. I call them like granny flats, another building or an extension to your house, which can be rented to somebody else. And it gives you rental income. It's a very interesting idea. It provides housing. Well, the law has now been expanded that the ADU can be condominiumized. So you go through the county so that that becomes a piece of property all by itself. And the ADU can be sold separately from the primary unit. Isn't this interesting? A new form of property. What else is happening? And this is going to start in 2025. That the property, usually it's your residence and you add an ADU, but starting in 2025, there's no requirement that you're an owner occupier of the main resident. So that tells me it would be possible to build an ADU on a rental property, in the backyard. And now you've got 2 units that can be rented on that property. So property law is evolving. Daniel?
All right, and on the topic of property, we're also talking about property taxes. So you thought you were done with taxes, but we got you back in. And the reason why we've kept this slide or with this part of the presentation in for the last couple of years. We even did a standalone presentation on this new California Proposition 19 that affects property transfers from a parent to a child either in their lifetime or at death. And the reason why we kept it in here is we're just starting to now see the effects of the law that passed a few years ago. And so just to kind of go through briefly on the law, because again, hopefully I know many of you have seen the presentation before and maybe have learned this already, but this affects California property taxes, this new California Proposition 19. And so this is showing that for all transfers after February 16th, 2021, so again, it's been 3 years that this law has changed, that the parent can transfer their primary residence to a child and keep the property taxes to the same to the child if the child maintains the property as their own primary residence. So again, we used to have a more expansive way to transfer properties to children without changing property taxes. It's now a very narrow rule of when the property taxes stay the same. And then again, even if the parent, dies, child moves into the parent's house, lives there as their primary residence, if the value of the property in the parent's lifetime appreciated, really, for the most part, more than $1 million above, what they paid for it, that the property taxes will still partially go up. So again, even if the child lives in the house, the property taxes may still go up by a certain amount. So again, that's sort of the basic rule of Prop 19. The big deal of why are we talking about this again? Again, the law passed 3 years ago, but people had to die. So now people died in 2021, left the property to the child. Maybe the child did live there, didn't live there, didn't maybe file the right forms. So now we're seeing the assessor's office who does the reassessment of these properties at death. They may not have known that the parent died. The child even may have transferred the property into their name and filed some of the forms to transfer title. But again, the assessor doesn't really know until they get caught up on some of these things. And our San Diego County Assessor's Office is like 6 months to a year, maybe even like a year and a half behind on catching up on these property transfers. And so they're sending out these notices to these children that have received the property from the parent. It doesn't have to be at death. It could be in their lifetime. There could have been a lifetime transfer. But the assessor didn't tell them that, hey, you needed to file something because they didn't know about it. The big deal about that is there's a 1-year period of when the child has to file the right forms with the county assessor's office to keep the property taxes the same. So the problem is people aren't knowing about it, or people don't know about it, and the assessor hasn't kind of given them help to say you need to file this thing because a year has already passed because the assessor is so far behind. And right now, the assessor is taking the position as if you miss that 1-year deadline, that's it. The property is going to be reassessed. So even if you moved into the house and occupied it as your primary residence, it's going to be assessed definitely for the period from the date of death to the date you kind of maybe filed the right forms. So that alone could be $10,000, $15,000 of property tax reassessment. And potentially going forward, it could stay at that higher property tax assessment amount. Sometimes they might lower it, but again, we're just now seeing the cases where uh, somebody missed that sort of 1 year deadline and we're having to deal with it. So if it's happening, with our firm, multiply that by how many times it's happening across the county, probably the state. And I feel that the assessor's office is going to be overwhelmed by a lot of appeals of this new parent-child exclusion rule. And so again, this is something we're still talking to all of our clients about, coming up with these plans. And there's, some issues with having to file this homeowner's exemption form. So that's the main thing that they're looking for, is this form has to be filed within 1 year after the date of the parent's death or the transfer. And again, as unfortunately many of you know, sometimes it can take more than a year to administer a trust. So how could somebody file the form if they didn't even own the property? They couldn't move in for a year. What if it went through probate, or there was conflict among the family of who's going to own the house? And maybe it was unoccupied for a year, and then the child moves in. Again, we're seeing sort of the ramifications of this law that many people are not happy with. And so again, the big question that we're asking pretty much all of our clients is, if you own a house here in California, do you think any one of your kids would want to move in there or live there or keep the house after your death? And then if most people don't really know, but if they say yes or maybe, that's the time that we get into this Proposition 19 planning. So, what can the parent do about it in your lifetime? And so there's some options that you could include in the estate plan. So in the trust, you could say, one, I give this house to that child so that they can, take it as their inheritance. If you wanted to do like an equal division among, let's say, maybe you have 3 children, you could give that one child what's called a right of first refusal, or an option to purchase the property from the trust. That provides them and the trustee a little bit more flexibility after the death in order to get the house as part of their share. And again, there's also, if you're sort of past that point, maybe the person died, there wasn't this right of first refusal in the trust, there are specific types of loans that happen within the trust. So again, I die, my estate's supposed to be divided equally among my 3 kids, one of them wants the house. If they were to buy out their siblings, that could cause the reassessment of the property, because again, it's not a parent to child transfer, it's a sibling transfer. But if the house is in the trust, again, I've died, the house is in the trust, if the trust can get enough money to do an equal division among the 3 of the children, that one child can take the house as part of their share. So again, there's always some important things to consider when administering a trust, and that's why it's good to work with an attorney, to represent the trustee in these things. Other things that you can do, again, in your lifetime for this Proposition 19 planning, is if you have not yet purchased a property, that maybe consider purchasing it in the form of an LLC or like a partnership with the children, because when you're initially buy the property within an entity, there's different rules that apply, so it's easier to plan around than the parent-child rule because it's so narrow now. Similarly, if you wanted to co-own a property with a child, maybe you're going to loan them the money to help buy it. There are ways to sort of take title from the parent and the child together at the time they purchase the property, where if it's set up the right way and the parent dies, it can go to the child without the reassessment.
All right. So you're right. We're back to taxes. I shouldn't have said we're not doing taxes. Let's talk about retirement plans. And when I say retirement plans, I'm talking about IRAs, 401ks, pension plans. These are all plans that have accumulated investments that haven't been subject to income tax yet. So what happens in my lifetime? The wonderful thing about retirement plans is they grow and grow and grow, tax deferred. The power of compounding, it just gets bigger and bigger. But there's a limit. There's a time at which I must start taking distributions. During my lifetime, I have to take required minimum distributions, which we call RMD, at a certain age, and the ages have increased depending on when you were born, If you're born before 1951, you're still at 70 and a half. You have to start taking the distributions. After 51 to 59, you start at age 73, and even later, you start at age 75. And it sort of acknowledges that people are living longer and people are not retiring that early. So how is the withdrawal taxed? Every time I take $1 out, that's ordinary income, absolutely ordinary income. Unless it's a Roth, I get to draw that out without income tax because the Roth was created with after-tax dollars. And the next slide, we have some interesting things that can be done in the field of charitable giving if you're charitably inclined. You can, at age 70 and a half, transfer $105,000 per year from your retirement plan directly to a charity, and that counts as your required minimum distribution. And it's a wash because it came to you, but it went to charity, so there's no income tax on it. You can get the whole thing to charity. You might think, well, can I help charity but help myself too? There is a one-time thing you can do. You can transfer $53,000 to a charitable remainder trust or a charitable gift annuity where you retain a payout during your lifetime of a portion of what was put in there. But eventually after that, it does go to charity. So that can be done one time in 1 year. Let's go to the next slide. All right. What happens in the event of my death? It used to be that whoever was my beneficiary could withdraw from my retirement plan using their life expectancy. And life expectancy is so long, they would only have to take minimal withdrawals every year, maybe 4% a year of the value. And the retirement plan keeps growing. Well, those days are over. Now at a death, we have 3 different rules. Certain people can continue to use their life expectancy for required minimum distributions. Fortunately, it's the spouse, which we're all used to that rule, a minor child till they get to a certain age, a disabled or chronically ill person. And yesterday was the first time I actually advised a real family. There is a son who has a disability. And I said, well, you know, withdrawals can be made over his life expectancy. That retirement plan can continue to grow, and he only has to take those small distributions. And the beneficiary less than 10 years younger. So that would be like your sister or your brother. 5 years. Oh, you don't want a 5-year mandatory distribution. What does that mean? It means after a death, everything has to be drawn out of that plan within 5 years, and the income tax has been paid. We call that an IRA blowout. That's a mistake. And it goes according to the beneficiary. If you designated your estate as the beneficiary, or you never designated a beneficiary, or there's a beneficiary who's died, or you've made it a trust, which isn't a special kind of trust called a see-through trust, that's the blowout, that there has to be a withdrawal done in 5 years. But for most everybody, for most children and next generation who are inheriting retirement plans, they're going to fall into the 10-year rule that they must do the withdrawal within 10 years after their parent dies. And during the 10 years, they must take required minimum distributions. And a lot of people are saying, if I wait till the 10th year to take most of it, that's going to be an enormous amount of income in 1 year. So most people are deciding on taking installments during the 10 years, actually, so that 10th year, they're not stuck with some huge amount of income. What's the takeaway? So many words talking about retirement plans. Check your beneficiary designation, because that's going to determine how long can the IRA stay in existence after your death. And people tell me, oh, I think I named my spouse. I think I named my children. I don't want to hear who you thought you named. You have to get a copy of the beneficiary designation. I'm going to nag you, and keep it with your estate plan. It's as important as your will, your trust. Get a real copy. And if it's not right, update it. You want to have a first beneficiary, and if they're not living, who's the contingent beneficiary? Daniel, back to you.
All right. So now this part of the presentation is meant to go over cases that came out in the last year, our legislation that has changed regarding just general sort of probate law and trust law. And so again, we're also going to try to give you takeaways for every case that came up, because there's a reason we're talking about it today. The first one, we're notifying your fiduciary, again, your trustees, whether you are a successor trustee or your professional fiduciary, or again, you're just the parent who created a trust and you've named your kids as the trustee. This is for everyone to know. The first case is US v. Paulson. And so this is regarding Alan Paulson, who was the founder of this big aviation company, who died in the year 2000. So this is how long these things take to come to fruition. So this is an estate that was created a long time ago. Alan died with an estate of $200 million. So even back in 2000, that was above the exemption amount. So he did have to pay an estate tax. And there are certain rules about paying an estate tax. One of them is that you can get on a 15-year installment plan to say, you know, it would be difficult for the estate to have to like liquidate, especially if it's all a business. Why would you have to sell the business to pay the estate tax? Can the estate get put on an installment plan over 15 years and pay the estate tax? You're allowed to do that if the IRS says so. In this case, this is what the trustee did. He got it on an installment plan to pay the estate tax. He did distribute a lot of the assets out to the beneficiaries. However, at one point during this installment period, the trustee failed to make a payment. Again, just like, you know, you didn't pay on your car loan. Now the IRS is going to say, well, now you've defaulted. No more installment plan. It's all going to be due. And so the trustee made a big mistake by just missing a payment. And then the trustee said, well, there's not enough money to pay all of this. All of the assets have been distributed out to the beneficiaries. So the IRS said, okay, not only are we going to sue the trustee or the executor of the estate, we're also going to sue the trust beneficiaries and try to collect from them. And they were successful. So the IRS was able to seek payments, so personal liability, for these unpaid taxes from the recipients of the estate. So again, there's probably lots of litigation surrounding that as well, maybe suing the trustee from the beneficiaries. And so when we work with trustees and we advise them, you know, if you're going to be doing a distribution, make sure all the taxes have been paid, or at least hold on to a reserve to pay for what you estimate the taxes could be if we're trying to distribute the assets of the trust. So again, it's very important for trustees to be very cautious. Don't just sort of bow down to the beneficiaries. You know, they need the money now. I mean, if you distribute it out, you could be liable, they could be liable. They're probably going to sue you, even though they told you to distribute the funds, because it could be by the time they get it, you know, they've already spent it. So good luck getting it back from them. So be very cautious if you're a trustee. And by the way, the tax bill, the estate tax bill for the Alan Paulson estate, it was about $10 million. So again, there's a reason why this became a big case. Some other changes in the law. Again, this has to do with our probate code. So when we talk about the probate code, that most people think, well, my estate's not going to go through probate, don't have to worry about it. No, so the probate code is really just the overarching kind of guidelines on how to administer trust, and kind of has like the default laws. If your trust doesn't explicitly say, you know, this is the exact way everything's supposed to go, the probate code will sort of fill in the blanks. So this is a big change for California. California is typically kind of this standalone state that doesn't really follow all the other rules that most other states will kind of follow under these uniform acts that are passed across multiple states at once. However, California now has adopted the California Uniform Directed Trust Act. So how this could come up is to say, normally I would have like my revocable living trust, and I name a successor trustee. I die, the trustee takes over, administers the trust. So they manage the assets, they liquidate the estate, they do the investments, they look at the plan of distribution within the trust, and they distribute the assets to the beneficiaries. Could be all at once, it could be over time, it could be for the rest of the beneficiary's lifetime. Again, that's what the trustee is going to be tasked with. They have to do all those activities. Under this new act, somebody could add an additional trustee, basically, or another type of fiduciary called a trust director. So it's just kind of adding another person in. So you would have your successor trustee, and you could add a trust director to say, trust director, I want you to be in charge of just a couple of those actions. So maybe you're going to be in charge of the investments, and the trustee will do the distributions, they'll file the taxes, they'll do everything else, but I'm going to have somebody else be in charge of the investments. Or they could be the distribution trustee. So again, regular trustee, you're doing the investments and everything else. But when it comes time to distribute the assets to the beneficiaries, we're going to have this other person take care of it. A lot of people think that this is kind of like creating co-trustees. So a lot of times a client will come in to see us and say, well, can I name two of my kids to be the trustee? I like the idea of checks and balances. And we say, you can. We don't typically recommend it, but if you want to have co-trustees, you can. Some people want 3, 4, 10 co-trustees. You can have co-trustees, so we've always had that. But if they're just a co-trustee, they're each liable for each other's actions. So it's, even though you're naming 2 people, they're not really delegating amongst each other. One person take care of this, another one do that, especially for liability purposes. They're both in charge of all these decisions together and are both liable. But now with this trust director, you could sort of separate the roles and insulate maybe the main trustee from what the trust director is doing. When things go topsy-turvy, I would say a trustee is never really going to be insulated from a trust director or another co-trustee. So that's sort of what the law is meant to do. And so again, you could sort of just add this one trust director to have certain powers. How could it come up? What we've seen that some people are talking about is, let's say you do have a special needs trust. So again, you set up a trust for a child who has a disability, who has government benefits coming in, and if they were to receive the inheritance, the money could disqualify them from receiving the government benefits. So you set up a special needs trust to sort of say, whatever the trustee's getting or the child's getting for their disability from the government, the trust can sort of supplement those things and not jeopardize the government benefits. Well, you may think about having a trust director in charge of maybe doing the investments, or specifically with a special needs trust, the distributions are so specific on how to use the money for the child's benefit. You may want to have a professional distribution trustee be in charge of distributing certain funds to or for the benefit of the child with the disability. So there's pros and cons, but again, it's not something that I would say we would routinely recommend for most people. All right, still me. Next, again, right now we're talking to a lot of trustees, but also for our clients, keep this in mind. This is everything you're naming your child or friend or accountant or whoever as your trustee. These are all the things they're going to have to deal with. Another big deal about administering a trust. So again, not my revocable living trust. When it's my trust, my assets, I can invest them however I want. I could put it all in some stock and be speculative and invest and grow, and I could lose it all and I can't sue anyone because it was my decisions. When I'm a trustee for somebody else, or let's say I've died and now my kids are the trustee managing it for the benefit of their siblings, they do have certain rules to follow in management of the trust assets or the investments. And so now the new law in California is called the Uniform Fiduciary Income and Principal Act, which replaces and actually repeals the law that we used to have for my whole practice, was the Uniform Principal and Income Act. So it used to be that there was a very specific set of rules that a trustee would have to follow in managing the assets and doing the investments. Now that's changed, so we kind of reset our mindset when we're talking to trustees, especially financial advisors. We're no longer following the Uniform Principal and Income Act. And so this changes what we used to refer to also as the prudent investor rule. So it was a very kind of specific way to manage trust assets. And they used to be that you would sort of have to sort of balance out the interests of income beneficiaries versus principal or remainder beneficiaries. So again, you can set up these, trusts that say, for the lifetime of my spouse, upon my death, my assets pay only income to my spouse. So they only get interest and dividends, maybe net rental income, but the principal stays in the trust. So that used to be that you would have to be very specific of how you invest for those things to make sure you're meeting the spouse's needs Then again, upon their death, the remainder beneficiary could be my kids. So the law's changed. And so it provides more flexibility for trustees in administering those types of trusts. And what it does is it allows them to invest for total return. And so kind of the main thing that we would be talking to clients about is it used to be a big deal to allocate income or principal to income. So again, in our trust world, let's say I've died, my trust holds, stocks, bonds, and things, and maybe the income, great, is interest and dividends, and that just pays out to whoever it's supposed to pay out to. But if I were to sell some of the stock and cause capital gain, in the trust world, that's considered principal. And normally a trust could say, don't give out any principal, just the income. And so there was a very specific rule of to treat the principal as income in certain situations under the old law. The new law, it's much more forgiving. So again, for these ongoing trusts or these trustees or even accountants, if not all the time will a trustee deal with their attorney every year on administering a trust. A lot of times it's the accountants and financial advisors. That is something to be aware of. There's this new Uniform Fiduciary Income and Principal Act that may make it a little bit easier or more flexible of distributing principal, or at least just how they handle the investments. Okay. Other big changes. So part of doing your estate plan, most people are thinking about what happens at my death. A big part of it, though, that we'll always try to hit on is this could come into effect in your lifetime if you are alive but become incapacitated. So for like medical decisions, that's why you have your healthcare directive, is to say, if I can't make a medical decision for myself, somebody has to do that for me. That's what we call incapacity planning. Similarly, on the financial side of things, you also have your successor trustee or your agent under your power of attorney that can step into your shoes financially if you can no longer do it for yourself. And this law actually changed that we're going to talk about last year. But again, it's such a big impact. We want to talk about it again. And there's probably lots of trustees that don't know about it, that they may actually have some action that they need to take like today, really. So the law has to do with when do you notify beneficiaries of the trust? And when do you have to account to them of the assets of the trust? It used to be only upon the death of the creator of the trust. So again, in my trust, I'm alive. I don't have to give a copy of it to anybody. I don't have to tell them what the assets are. Great. And it used to be in my lifetime, if I became incapacitated, the successor trustee steps in, and now they're in charge of managing the assets of the trust, still for my benefit, that they did not used to have to give out a copy of the trust or account to anybody. But as of last year, 2023, the law changed to say now that successor trustee, if they receive information that the creator of the trust, called the trustor, is incompetent, now they do have an active duty to provide written notice to the beneficiaries within 60 days of receiving the information of the incapacity. They notify them. They have a duty to send out a copy of the trust and all of the amendments and account to the beneficiaries every year, really for the rest of the life of the trustor, unless the trust says otherwise. So again, this is a brand new law. So really, any trust written before 2023 wouldn't have even brought this up or wouldn't have even contemplated this because it wasn't the law. So if you take over, you're the child of the parent becomes incapacitated, you get maybe like those 2 doctor's letters to certify the incapacity. You take those doctor's letters to the attorney, to the bank, you get on the accounts, you get on title to the house. Now you're using all the money to pay for your parents' living expenses, medical bills, all those things. You file their taxes. You actually do have a duty to send out a copy of the trust to your siblings, to the charities, to anyone that would inherit if the trustor died. So if your parent dies and everything's divided equally among you and your siblings, you have to give notice you have to send out a copy of the trust and the amendments to the siblings and then start to account to them every year. And the accounting is showing to the penny what you started off with. So let's say it happened to be January 1st. So these were all of the assets as of January 1st. This is the bank account. This is how much was in there. This is the house. I got it appraised. And then you have a list of all the income. So interest, dividends, rental income. You have a list of all of the expenses, including disbursements to the parent and like what your fee is if you're taking a fee. All of that goes on an accounting record that you give out to the beneficiaries every year. And so unfortunately, that means that, your siblings or whoever the beneficiaries are seeing how are you spending the money to support your own parents. And that could cause the situation you can imagine where they're saying, oh, why are you putting them up in such a nice facility or paying for home health care? I'm seeing my inheritance dwindle down. You're spending it all, and I really need this money. I've already spent it in my mind. And so what some people are doing, so you could opt out of it is the thing. It's automatic by default that you're kind of part of the program, but if you don't want that to happen, you could say in your trust, so you can meet with your estate planner today and say, I don't like that. I want you to put some language in my trust to say, if I become incapacitated, my trustee does not have to notify anybody. They don't have to account to anybody, and that's it. And then the trustee doesn't have that duty to do it. The way the law was written, it really does say the successor trustee has to receive information of incapacity. Well, there's lots of times where maybe, mom and dad were alive, dad died, mom needs some extra help with managing the money and, the finances and things, paying the bills. So they'll bring their successor trustee up to be a co-trustee with them. At that point, if mom becomes incapacitated, the trustee doesn't really have to do anything. They can keep them on the accounts, pay the bills, take care of everything. They don't have to get the doctor's letters. There's no duty to do that. And then in that case, they don't have to necessarily notify the beneficiaries or account to them. Other times, in that situation, mom says, or dad, whoever is going to resign as the trustee. So they could say, I'm going to, I've been diagnosed with something, or I don't want to take care of these things. I'm only awake for a few hours a day. You take care of the finances. I know you've been doing it already. That's the shadow, child in charge. The parent could step down, child becomes the trustee. Again, the parent still has their capacity or may lose it in the future. At that point, no duty to notify anybody or send an accounting or anything like that. So it's come up a couple times, where we've talked to people about this new law. And as an example, where we kind of opted out of it is when there was only charities that were beneficiaries. So the husband and wife had no kids, leaving all their assets to various charities, which, they're likely going to change many times in their lifetime. They don't like the idea of that charities knowing, what they're going to get or how much the assets are. So we just said, okay, trustee, you don't have to do it. So they opted out. And so if the husband and wife become incapacitated, the trustee steps in, no duty to account or notify anybody. So again, it's not something necessarily that I think every estate planning attorney is talking to every single client about, but it's definitely on our checklist to bring it up if it seems like it could cause some problems. Oh my gosh, it's still me. Okay. I think,
You wanted all the alerts.
yeah, I did. Okay. So these are all relating to trustees. So believe it or not, they're kind of related. And they really are these huge changes that we're seeing in trust administration law. So again, a lot of people don't realize that you don't have to name a family member, a friend, your professional advisor as your trustee. If you don't really have anyone that is the right person for the job, there are what are called professional fiduciaries. And so this is someone whose whole career is to be a trustee for somebody else. So it's a professional trustee. And it could be an individual, it could be a group of people, but they all have to be individually licensed. And so you can become a professional fiduciary and you're licensed by the state and you get insurance and bonded and all these things. And so it's a whole career that exists. And we're seeing, probably hopefully more and more people entering that type of field. And so what are the changes with these professional fiduciaries? So again, we're talking to you professional fiduciaries, I'm sure you know about it. Or if you have a professional fiduciary named in your own estate plan right now, you can always talk to them to make sure they have this, but now a professional fiduciary can name a practice administrator. So this is to say, let's say I'm a professional fiduciary. If I die or become incapacitated, and I was acting on behalf of your trust, or I was the last person named as the backup on your trust, and now there's nobody named after me, oh gosh, now your trust is in limbo because there's no acting trustee that can do anything about it. It used to be that somebody would have to go to court and deal with waiting and fees and all these things. But now a professional fiduciary can appoint their own, in a way, a successor. They can appoint a practice administrator. So this is where they say I name another licensed professional fiduciary. So they do have to be licensed to act as my successor or to act on behalf of any trust or estate that I'm administering. So it can be within their power of attorney. They can name their practice administrator, could be an estate, their executor, estate personal representative, their trustee. So again, attorneys, we already have this. So any licensed attorney can name a practice administrator to, let's say I was solo attorney and I have all my clients and cases and all these things. If I die or become incapacitated, I'm authorizing another attorney to step in to deal with the files. So again, not necessarily like take over the business, but deal with the files on behalf of the attorney. So now a professional fiduciary has the same ability.
Oh, back to me.
Yeah.
Wake up. All right. Is it a will? This morning I was thinking, what's the most unusual will I've ever seen? This goes back quite a ways. I had a client bring in a business card, and on the back, which is, plain, the decedent had written a will. I leave my entire estate to my sister, so-and-so, and signed it and dated it. And I said, well, that's a handwritten will. That's a holographic will. And I sent it down to the court for filing. I stapled it to a piece of paper and started the probate, and everything was fine. But sometimes there's a real question about whether a document actually is a will. In the estate of Berger here, the decedent wrote a letter. Here's the letter. It was printed as in on a computer, signed, dated, didn't say it was a will. It said to whom it may concern. There were no witnesses. And the letter said, my estate entirely goes to my fiance, so-and-so. And the relationship with the fiance ended 6 months later. Fast forward, the decedent dies 18 years later. Is this letter the decedent's will or not? The decedent's sister wanted to say, that's not the will. I inherit everything through intestacy. There wasn't a will. But the court said, we're willing to listen to this situation. We're willing to take extrinsic evidence. So from law school, we have to remember only certain times is a judge allowed to listen to the facts surrounding the case besides what was written on the letter. So here's a judge not listening to extrinsic evidence. He has his hands in his ears going, la, 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 la. But in this case, the court said, we will listen to extrinsic evidence, and we do believe that this was a will. It was a testamentary letter. So as Daniel always says, you don't want to wind up in our handout. Do your wills, do your trusts correctly, so you don't wind up as one of these cases. All right. Next case. We have a decedent who named his nephew, who he was very involved with. The nephew helped the decedent, who was aging, and the business, named the nephew as an authorized signer on the bank account. So you can always go down to your institution and say, I want so-and-so to be able to sign on my account. And that's a power of attorney on the account. This decedent also named the nephew as the agent on a formal power of attorney created by the estate planning attorney. Well, the nephew withdrew from the account, and it was a lot of money during the decedent's lifetime and after his death, and took out money for himself. So the nephew breached his fiduciary duty under the power of attorney to use the money only for the benefit of the principal, for his uncle. He couldn't use it for himself. And it really was a lot of money that he took. He was liable for about $275,000. Daniel, back to you.
Yep. And so now we're going to go over a couple of cases that all relate to how do you amend a trust. And so again, this is actually bringing forward a couple of things we talked about last year. The reason why it's so important is now we're seeing this log jam of cases coming that are kind of all relate very similarly to just amending a trust. Sounds pretty simple, but you can imagine the situations where, whoever's on the short end of the amendment is going to want to say that amendment was invalid. And so the newest one that we have is this Diaz v. Zuniga case. And so the facts in this case was that the decedent, so Diaz, had a trust, and then he did a self-amendment. So he said, on a piece of paper, I'm amending my trust, and I'm changing these paragraphs. And of course, I'm changing the distribution plan, saying who's getting what upon my death. So he wrote it down. he signed it, he put it in an envelope addressed to the estate planning attorney to say, make these changes, but he never mailed it. He put the envelope in his closet, maybe for another day. And of course, he died and the envelope was found. And so we had a trust, and then we had this maybe amendment. And of course, the child who was maybe written out of the amendment said, this amendment's not valid. We're just going to follow the trust. And so everybody got upset. And then now it went to court. And the main issue was, well, did the Diaz who created the trust, did they do a valid amendment? And so most of the time, anytime you're looking to see, was something done properly regarding a trust, you look to the trust. A trust will say, what is the way to amend this document? And it could say it has to be signed and delivered to the trustee, which again, if you are the trustor and the trustee, nice and simple. It could say it has to be notarized. It could say it has to be sent by mail. In this case, the trust actually required, in order for there to be a valid amendment, it must be delivered by certified mail to the trustee, who at the time was Diaz. So technically, he would have had to make the amendment to the trust, sign it, send it by certified mail to himself. That would have been the right way to amend the trust. So obviously, maybe not what was intended, or maybe sort of what the attorney maybe could have changed their documents, to not really have that requirement, but that's what it said. And so in this case, the court said, nope, the trust said that's the way you amend the trust. Our probate code has other more forgiving ways to amend a trust, but the court said, nope, the trust said this is how you do it. You didn't do it. It was not a valid amendment. So again, that's the situation where the court said you have to follow what the procedure under the trust. The other case that came out last year is what we call the Balistreri case. Very similar facts. In this case, it was a husband and wife that signed an amendment to the trust the day before the husband died. These are like these movies and TV shows we're seeing now. So they signed an amendment to their trust. It was not notarized, which again, in the statutory probate code, that's not a requirement. But most attorneys do have these documents notarized, just to make sure this is who you say you are, and this is what a valid change was. So a lot of times when you're making an amendment to your trust in your attorney's office, it's going to be notarized. But again, in that case, it was not notarized. Both husband and wife, both passed away, the husband died. And then the issue was, again, was this a valid amendment? And same thing in the Zuniga case is that because the trust said any amendment must be notarized, the trust said that's the only way you can amend the trust. If it's not notarized, it's not an amendment. So again, the court took the very strict rule to say only follow the trust, even if there's other ways, within the code to do it. The trust explicitly says the only way to do it. So again, these two cases are saying follow the exact procedure under the trust to amend it. However, we are now dealing with the Haggerty v. Thornton case, which was also really came out, I think now like 3 or 4 years ago is when it sort of started. This case is under review by the California Supreme Court, so it's sort of the highest court in the land for us, other than the federal Supreme Court. That is going to be decided hopefully soon. This case was actually argued just December 5th, and believe it or not, it's actually with a local attorneys and a local fiduciary that is kind of involved in this matter. So this is all really a San Diego trust and estate matter that's going to have changed the law potentially in California when it's decided. So in this case, again, the trustor, the creator of the trust, prepared a handwritten amendment to her trust, and of course, changed the distribution plan. That's the only time people get upset, is when they're not getting as much money as they wanted, to omit a beneficiary. Again, in this case, the trust also required the amendments to be notarized. It was not notarized. And of course, after the person died, whoever was getting omitted tried to sue the trust to say, this is not a valid amendment because it wasn't notarized, and the trust said you have to notarize it. In this case, the court, the lower court, did say that is a valid amendment, even though the trust says you can amend by getting it notarized. The court was more forgiving and said, although if it's not notarized, there's statutory procedure in the probate code, and they follow those rules. So we're going to say you could do one or the other, follow the trust, follow the statute, unless the trust says don't follow the statute. So again, that was sort of their reasoning behind it, is the trust didn't say This is the only way to do it, no other way possible. So again, in the Haggerty v. Thornton case, much more forgiving, but it is on appeal. And so hopefully we'll get some answers by our next year's presentation if you're going to come watch with us, where we'll get an answer to say, this is the way to amend a trust. Overall, what you're all alive and watching this. So what can you do to avoid being in this logjam of cases or saying, are you following the rules? Are you not following the rules? Just meet with your estate planning attorney. We know, hopefully it's just something small that can be done, very simple. But again, little changes can have a huge effect where if you're not following the right way to amend the trust, it could all be disputed and objected to and cause lawsuits after your death. And so just make sure that you're following the rules, meet with the professional to get it done the right way. And because again, even little ambiguities here and there can cause a lot of problems after the fact. And we always say the reason you won't know that you did a good or bad job if you try to do it yourself until it's too late, because then that's the only time anyone would look at it is after your death, and you're not there to explain it.
Well, let me talk about some takeaways, and Daniel, you can chime in. After I go to continuing education conferences, I'm like, my brain is full. And I think, wait a minute, before I leave, let me see if I can decide on maybe some main issues that I want to remember from this presentation. So we're making you a list of takeaways, hopefully to help focus on what do you really need to think about. Well, in the estate tax arena, we used to think 2026 was so far away. It's not far away, it's coming. And the exemption's going to go down to $7 million. Also, if you're a surviving spouse, a financial advisor, or a CPA, if you are dealing with a surviving spouse and the death occurred within the last 5 years, make sure that the survivor thought about grabbing the decedent's exemption, which they might need for the future. As long as it's within the 5-year period, it's not too late to make an election for portability to get that exemption. Daniel, you want to
Again,
take
big
next?
changes that we're seeing, day to day, dealing with all our clients. Still Prop 19 and property taxes. It's something that we really are talking to every single person about, and especially after a death. I mean, we bring this up very quickly in the conversation because you don't want to miss that year deadline after the death to maybe save tens of thousands of dollars of property taxes per year. And of course, in the person's lifetime, there's some planning around it. Retirement plan beneficiaries, especially with the change in the law, now we're getting a little bit more clarification as far as that 10-year withdrawal period that financial advisors and big financial institutions are kind of getting up to speed on these changes. And again, we know you don't see your attorney every year, but hopefully your accountant or financial advisor. And so they're looking to see, who are the beneficiaries? Do they need to be updated? If you have a trust as your beneficiary, again, we may have told you that a couple of years ago and for the last 20 years, but the law changed, so that's worthwhile to review your retirement plan beneficiaries. Again, with everything I went over with those trustee alerts, it really was a big year for our trustees. So I think the biggest thing actually happened last year is the duty to give the notice and account to the beneficiaries upon the incapacity of the trustor. So this is something that we're having to incorporate into our practice. And I'll say most people are not happy. So most trustees, when they come in, aren't really happy that they have to take these actions. I mean, it's enough already to, mom or dad became incapacitated and get caught up with the bills and where their accounts and get on title to everything. And now they have to start accounting to their siblings and tell them what's going on and see a distribution plan that maybe wasn't supposed to be given out in the parents' mind until they were gone. And sometimes we'll see the client and say, is this going to upset the kids? Whatever this plan of distribution goes, like you say, remember when we loaned that or gift, made a gift to that one child, 20 years ago? Well, now, they're going to get their share reduced because of that. And so we tell the clients, is this going to upset your kids? Sometimes they'll say, it will. I don't care. I'll be dead. Well, not anymore. You could be alive, and then this is all going to come to light. And then, of course, finally, amending the estate plan, a really big deal. Just do it the right way. You're going to end up in probate, if you don't do it the right way. And if you do have some questions, actually, go ahead and kind of leave them in the Q&A because we'll stay on for a little bit. Otherwise, that's really the end of the presentation. And just to go over everything, if you don't want ask your question today, but it comes up later, you can email us, or if you need to make an appointment, there's all our information. And of course, we are also doing this presentation live next Friday, the 26th at the Rancho Bernardo Library at 10 o'clock. If you just couldn't get enough, same topic, same presentation. You will all get a email after this presentation of the handout and the slides, and we're recording it, so you can get the link to watch it again. So again, thank you all for joining us today and staying on with us, and we really appreciate it every year. Thank you. Okay, for those of you that wanted to stick around, again, feel free to leave whenever. Some of the questions that are coming up in the Q&A, one of them talks about a will, and is it valid if it's notarized but not filed with the court or or if it's recorded. So wills specifically, they only get filed with the probate court upon your death. So in your lifetime with your will, one, it's not really notarized. So in California, we have specific rules of having the wills witnessed by two people who are not related to you, not named in the documents. So there's very specific witnessing requirements on a will, so they're not necessarily notarized. And again, nothing gets filed really ever in your lifetime on your revocable trust with the court or the county or anyone else. So again, your documents are with you. So also keep in mind, keep track of where your documents are. Let's see, another question came up. So does the trustee alert to inform the beneficiaries apply retroactively? I would say yes. So this is where a trustee has taken over, maybe due to the parent or the trustor's incapacity. They got the 2 doctor's letters or whatever the procedure is to inform them of the person's incapacity. I would say that yes, they do have a duty to notify the beneficiaries and start to account to them. Again, this is actually a very new law that I just attended another continuing education thing on, and it's still very vague. And in our position, when we're representing trustees, you're hiring us to make sure you follow the law and to minimize your risk. So our objective is to really minimize your risk in acting as a trustee. And so we kind of err on the side of, following the rules very clearly, even if it's vague. Great. So again, no other questions coming in, so we'll let you guys all. Oh, another question. Yeah, Prop 19. I was waiting for this. Roberta, perhaps you can answer this one. So
All right.
Yeah.
So there is a movement to put Prop 19, the repeal of Prop 19, the very restrictive parent-child transfer rule, on the ballot so that the voters of California can vote to repeal it. And you might remember, if you've been around a while, it was Howard Jarvis back in the 80s who really played a role in changing property taxes. And we got Prop 13, which we all love in California, that our property tax bill can't go up too quickly. So it is the Howard Jarvis Association, which has been sending petitions out for people, for people to sign up to put this on the California ballot. We'll see if they have enough signatures. The deadline was the 16th, which was this week. And I signed it. I want it to be put back on the ballot. I don't think the voters of California realized what they voted on when they changed this law. It was buried in another big proposition. So we'll see. Keep your eyes open for the news. I would be very happy that Prop 19 is repealed.
Great. So again, thank you all for joining us today. And there's all our contact information. So we really appreciate you hanging on with us and participating. Thank you.
Thank you.
One thing came up. It looks like the deadline has been extended for the Prop 19 to be put on the ballot to February 5th. So looks like some of you all are aware of this too. All right. Thank you all very much.
Thank you. Bye-bye.